Hello there and welcome to Rachel Rogers TV. I'm Rachel Rogers and I'm so happy to have you here. Today we're going to cover a very important topic about how to protect your intellectual property when working with contractors. Now, we all hire creatives to help us with aspects of our business. We are always in need of additional creative assistance to complete our projects. The problem arises when you don't have an agreement with that contractor, or even when you do, but you don't understand what's in it. The question that we want to answer today is, when you hire a contractor, who owns the intellectual property? Simply because you're the paying customer does not mean that you own the intellectual property. In fact, in most cases, you don't own the intellectual property. Yes, really. Unlike with your employees, when you hire a contractor, it's actually the creator of the work, so it's actually the contractor themselves that owns the intellectual property. With employees, the employer owns the intellectual property, and I'll talk more about that in a future episode of RRTV. So most people attempt to get around the fact that they've hired a contractor to create IP and the fact that the contractor is the owner of that IP by having a work for hire clause in their contract. Have you heard of work for hire before? A lot of people have, and they simply think that as long as I have a work for hire clause in my independent contractor agreement, then I am good to go and I own the intellectual property that the contractor that I hired to created. Unfortunately, in most cases, that is not true. Work for hire is a complicated statutory law. It has some very specific technical requirements, and most work for hire clauses that you see in contracts actually do not comply with the statute, which means they are not enforceable, which means that you don't own the intellectual property that your contractor created for you. The good news is that you don't have to know or even understand how work for hire works in order to cover your ass when it comes to your relationships with contractors. Instead, what you want to focus on is a grant of rights clause. Unlike its pain in the ass cousin work for hire, grant of rights is pretty straightforward and is always guaranteed to get you what you want. The grant of rights clause lays out who gets the ownership rights to the intellectual property in an independent contractor relationship. The grant of rights clause will typically grant either full or partial rights to the intellectual property to the purchaser. So what this clause is doing is transferring the intellectual property from being owned by the creator to being fully or partially owned by the purchaser. For example, a grant of rights clause can have the creator retaining ownership rights to the intellectual property while at the same time granting a license to display to the purchaser. Let's say you hire a professional photographer to take beautiful photos of you for you to use on your website. Well, you want to be sure that you can use those images for the purpose that you intend, because otherwise, what the hell is the point if you can't slap those bad boys up on your website? To be sure you can use the photos the way you want to use them, you would need to look at the grant of rights clause in the agreement between you and the photographer to determine exactly what the photographer is granting you the right to do. Let's look at this clause together. All images, digital images, photographs, and prints, hereafter images, produced by the studio are original works of authorship protected by the United States Copyright Act. Studio owns the copyright in and all intellectual property rights to all of the images and reserves the right to exploit the intellectual property rights for display, publication, advertising, or other purposes. Upon receipt of final payment, client is granted a non-exclusive, unlimited license to use the images for personal, non-commercial purposes. So what the hell does this clause mean? What's happening here is that the photographer is going to retain ownership rights to the intellectual property. That means the photographer will own the copyright to those images. What the photographer is doing is granting the purchaser a right to use the photos for personal, non-commercial purposes only. That means that you couldn't use these photos for your business, could you? So if you wanted to use these photos in a commercial sense, you would not want to sign this agreement with this photographer because that would limit how you could use the photos. This is an important distinction to make, and it's absolutely essential that you understand the grant of rights clause. There is nothing worse than getting to the end of a project and finding out that you can't use the intellectual property in the way that you had planned to. I've seen this happen many times over the years. One situation involved a business owner who had a long-standing relationship with a designer. She had worked with the designer many times before. In this particular project, the designer did a bunch of original illustrations for this particular business owner's website. The business owner is thrilled, the designer gets paid, all is good. Except when the business owner finds out the designer is planning on licensing out those same illustrations to a magazine. The business owner feels like this is a really essential part of her brand and that she cannot allow the designer to sell these designs and this essential part of her brand to other people, and therefore a legal battle ensues. So the moral of the story, make sure you understand how the grant of rights clause works in any independent contractor agreements you sign. Intellectual property assets become very important when you're thinking about taking on a partner or an investor, when you are trying to value your business, and in other scenarios. And of course, when in doubt, always hire a lawyer to review your contracts for you to make sure you understand exactly how the grant of rights clause works in your agreements. So that's all I have for you today, folks. Thank you so much for watching Rachel Rogers TV. I really appreciate having you here today. If you enjoyed this video, please share it with a friend. And if you never want to miss an episode of Rachel Rogers TV, just use the subscriber boxes below to subscribe. It's just like DVR. I will see you next time. Bye-bye.